Now, during the Industrial Revolution, a number of societal changes were beginning to take hold. Unfortunately, with the inauguration of Rutherford B. Hayes as President of the United States in 1877, Reconstruction ended in the southern states per the Compromise of 1877. Federal troops were removed, and the southern legislatures began passing Jim Crow laws, which all but ended civil rights in the South. Civil rights was going backwards at this time. Now, in 1892, Homer Plessy, a person of mixed race living in Louisiana, volunteered to be a defendant in a test case challenging the Separate Car Act. Now, this act was a law passed by the Louisiana State Legislature in 1890, which required separate but equal train car accommodations for blacks and whites. Homer Plessy bought a first-class ticket on the East Louisiana Railroad. He sat in the whites-only car. The conductor ordered Plessy to remove himself to the black-only car. Plessy refused and was charged with violation of the Separate Car Act. He was found guilty in the state court. Losing in the Louisiana Supreme Court, Plessy and his lawyers brought the case to the United States Supreme Court. Now, Plessy and his lawyers brought the case to the United States Supreme Court. Plessy's legal team argued that his rights were violated under the 13th Amendment and the 14th Amendment. Now, the 13th Amendment outlawed slavery, but due to the reputation of being a black man in Louisiana, he was thought of as property, which by the law implied the inferiority of the African American as compared to the whites. 14th Amendment, which stated, "No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process, nor deny to any person within the jurisdiction the equal protection of the law." Plessy was denied equal protection in Louisiana under the Separate Car Law, which violated his constitutional rights as an American citizen. Okay, Supreme Court decides the case on May 18, 1896 in a 7-1 decision against Plessy. Writing the majority opinion for the court, Justice Henry Billings Brown dismissed the 13th Amendment argument out of hand, stating that it does not conflict with the 13th Amendment, which abolished slavery and involuntary servitude, except as punishment for a crime, is too clear for argument. Slavery implies involuntary servitude, a state of bondage, the ownership of mankind as a chattel, or at the least the control of labor and services of one man for the benefit of another, and the absence of legal rights to the disposal of his own person, property, and services. Justice Billing affirmed the lower court's decision upholding Plessy's conviction when he stated, "The object of the amendment was undoubtedly to enforce the absolute equality of the two races before the law, but in the nature of things it could not have been intended to abolish distinctions based upon color or to enforce social as distinguished from political equality, or a commingling of the two races upon terms unsatisfactory to either." Now, laws permitting and even requiring this separation in places where they are liable to be brought into contact do not necessarily imply the inferiority of either races to the other, and have been generally, if not universally, recognized as within the competency of the state legislature in the exercise of their police powers. The most common instance of this is connected with the establishment of separate schools for whites and colored children, which has been held to be valid exercise of the legislative power even by the courts of the states where the political rights of the colored race have been longest and most earnestly enforced. In other words, as long as the separate facilities are equal, then there is no problem. The one lone voice on the court who dissented, meaning to disagree, was Justice John Marshall Harlan. He stated in his opinion, "Everyone knows that the statute in question had its origin in the purpose not so much to exclude white persons from railroad cars occupied by blacks as to exclude colored people from coaches occupied by or assigned to white persons. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. in respect of civil rights. All citizens are equal before the law. Humblest is the peer of the most powerful. The law regards man as man and takes no account of his surroundings or of his color when his civil rights are guaranteed by the supreme law of the land are involved. Harlan begins his conclusion of his dissent with this prophetic statement: the judgment this day rendered will in time prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. Now, it would not be until 1954 when the Supreme Court would overrule Plessy with its Brown versus Board of Education. Now, when Justice Billings handed down the majority opinion in Plessy, he unknowingly started a civil rights movement in America. Now let's look at Booker T. Washington, a leader in the late 19th century and early 20th century civil rights movement. Born into slavery in 1881, by the age of 25, he was the head of the Tuskegee Normal and Industrial Institute, known today as Tuskegee University. Now, in his Atlanta Exposition speech, known today as the Atlanta Compromise, Washington stated African Americans should concentrate on industrial occupations and learning of other practical trades that would give African Americans opportunity for economic advancement and wealth creation rather than other more intellectual pursuits such as higher education. In other words, show that African Americans are just as capable as white Americans in making money and fortune. Washington did not believe the way to equality was through demanding voting rights or to retaliate against racist behavior. He believed the best way to gain equality was by tolerating segregation and discrimination. However, there should be access to basic education, particularly vocational and industrial training. At first, the leaders of the early civil rights movement agreed with Washington, but a split was coming. Now, a gentleman by the name of W.E.B.DuBois, African-American intellectual, college professor, and founding member of the Niagara movement, advocated the pursuit of liberal arts education and active engagement for civil rights. These two men were the driving force for the civil rights at the turn of the 20th century. Now, 21-year-old Mabel Hallman claimed she had been raped by a black man. The racial tensions of the time, the accusation of rape, the victim white, the accused black, the inevitable happened. Two men were in custody in jail, a white mob determined to break into jail and lynch the inmates. The mob failed in their attempt, so went on a rampage. They destroyed dozens of black-owned businesses and homes in Springfield. 2 black men were lynched and 5 white men died during the riots. Later, during her grand jury testimony, Mabel Hallman admitted she lied about the rape to cover up her affair with a white man. Now, it is said that this event was the catalyst that precipitated the founding of the NAACP. The National Association for Advancement of Colored People was an organization that was chartered in 1909. Their pledge to promote equality of rights and eradicate caste or race prejudice amongst the citizens of the United States, to advance the interest of colored persons, to secure for them impartial suffrage, and to increase their opportunities for securing justice in the courts, education for their children, and employment according to their abilities, and complete equality before the law. Now, the NAACP pursued this mission throughout a variety of tactics, including legal action, lobbying, peaceful protest, and publicity. Now, quickly following the charter of the NAACP, the National Urban League Coalition amongst Negroes was chartered in New York City. This group advocated for economic and social justice for African Americans against racial discrimination in the United States, known today as the National Urban League. Now we have what's called the Morrill Land Grant Act of College Act of 1862. This set aside federal lands to create colleges to the benefit the agricultural and mechanical arts. The second Morrill Land Grant, though, in 1890, was aimed at the former Confederate states and sought to rectify discrimination. It required states to establish separate land-grant institutions for black students or demonstrate that admission was not restricted by race. The act granted money instead of land and resulted in the establishment of several historically black universities and colleges, including Alabama A&M, Prairie View A&M University, and Tuskegee University. Now, I put some links in the description below that get into the details on Plessy v. Ferguson, the Springfield Riots, Booker T. Washington, and W.E.B.DuBois. Now remember, review your notes every day for 10 minutes and try to pay attention in class. I know stuff happens, but try, it does work. This is just a brief history of how the NAACP began. I hope you like it, and if you did, please hit that like button, subscribe to my channel, and ring the bell. But most importantly, leave a comment below. Again, this is an overview. The best way to get the information you need is pay attention and take notes in class. Okay, anyways, thank you for watching.